and opportunities. Thank you.
Good afternoon, ladies and gentlemen, and welcome to GIPC. It is an honor and a privilege to moderate such an esteemed panel. We're discussing the rise of generative AI and the copyright concerns and opportunities. So generative AI, underpinned by the advancements of machine learning, and is revolutionizing the concepts of creativity and the business landscape simultaneously. Its applications range from generating art and music to automating content creation and software development. This technology not only redefines creativity, but also ignites critical discussions surrounding intellectual property, ethics, and the future of ownership of creative works. The rise of generative AI has led to significant debate, particularly regarding the copyright issues. On the one hand, generative AI democratizes the creative process, enhances productivity, and expands access to tools traditionally reserved for experts. Conversely, it raises pressing copyright concerns, including ownership of AI-generated work, potential infringement by AI systems trained on copyrighted information datasets, and ethical implications of using such works without proper attributions and compensations to the creators. The dialogue surrounding generative AI transcends legal and technological realms. It encompasses cultural, economic dimensions related to creativity, fairness, and innovations. Today we are going to look at both the advantages such as democratization of creativity, increased productivity, and enhanced accessibility that comes with AI, generative AI, while also looking at the other side of the coin, which is the challenges that come with generative AI, such as copyright ownership, infringement risks, ethical implications, fraud and misinterpretation. I would like to start the session by looking at one of the most critical points when it comes to copyright ownership, that is the understanding of author. So whether AI can be deemed as author or not, it's still in debate up till the Supreme Court. Supreme Court has not given its opinion on it as yet. And so I'd like to place the question to my panelists, and we could start with Aamod sir.
Thank you. Thank you. Good afternoon, everybody. Always difficult to start a session after lunch. So I hope you're all okay. So I want to take a different approach, okay? Let's take a step back. Let's take a step back because first of all, what does copyright protection mean? And what is the intent of the legislation? So copyright protection, as you all know, is a negative right. It's a right against the world. It's a right in rem. It's a right which has been granted to the author to protect the originality or the original expression and incentivize the investments, be it patent, be it copyright, be it trademark. Now coming to AI. AI is not a juristic personality. So it doesn't really need incentivization. It doesn't need the kind of protection that an author seeks. More importantly, it's not even investing in the creation. It's feeding off other third-party content, which is through the LLMs. Okay, so that's the first premise I'd like to place. The other is the definition of author itself in the Copyright Act, Section 2D. It specifically says the person who creates, even if it's a computer-generated creation, is always the person. So it's always the author who is deemed in law to be the person or the real person, and not a system of computer generation. That's the first. It's, I think, similarly placed across the world, okay? Across EU, across US, you have similar kind of, and of course, I like my esteemed panelists to add to that. But essentially, that's it. But there is an exception when it comes to authorship, and so the US Copyright Office basically it may allow you to register an AI-generated work, provided you're able to show sufficient human intervention. So now we come to what is called derivative works, or what are called transformative works. So when you have transformative works which are partly inspired by AI, but there is a substantial amount of human intervention which has gone into creativity, then it's treated differently. So that's the broad perspective I'd like to place. Thank you.
Ma'am, from you, if we could have the perspective when it comes to the patent inventorship and the AI interplay, along with how authorship is looked at. How would you deal with it, since you are a practicing patent attorney and IP lawyer?
So, as far as inventions are concerned, in India, you need a natural person to be an inventor. So, as of now, I don't see a scope for AI to be listed as an inventor. That's number one. Second thing, when it comes to inventions which are AI assisted, there the patent office is quite clear that they look at it more as, they treat it on par with computer programs. So they treat it in the same way. If there is a good technical effect, they will grant it a patent. As of now, though there are lots of patent applications which are being filed at the patent office, which are AI assisted as well, they do not look at it as, okay, there is an AI assistance in this particular invention, therefore should I treat it differently? No, they do not. They treat it as a computer program, and as long as they're able to find prior art, they look at the same criteria: novelty, inventive step, and utility. And then they say that, all right, it does meet these criteria and the patent is granted. There's no distinction made as of now. I do believe that in the future, maybe we should look at a little bit of a higher threshold when you want to grant such patents. Because if it is AI assisted, then the level of invention should be a little bit higher. But I guess that will come with time. We are still in the very nascent stages. Even when you are creating inventions, I have not come across, or they might be, but there haven't been any such kind of an invention where it is truly made only by the AI without human intervention at all. That has not happened as yet. So till we come to that kind of an era, we still will apply the 3K, and I think that's how patent office will look at it.
Thank you, ma'am. Shruti, you come with a very different perspective considering you practice in the US. So could you tell us what the current legal perspectives on authorship and ownership of AI-generated works is?
Sure. So in the US, we actually have pretty solid guidance from the US Copyright Office on this point. As Aamod mentioned, in the US, an author can only be a human person. So you cannot get copyright protection for something that is entirely AI generated. The Copyright Office has gone one step further and has actually opined on this, as well as granted registration, where a comic book was made of parts that were contributed to by a human person, but the graphic art generated was generated through AI. They've given copyright protection on the human piece of it, but have made it very, very clear that the graphic art that was AI generated is not going to have any copyright protection. In the US, this would generally mean that if you're using something that is completely AI generated, not only will you not get copyright protection, as Aamod was saying, it's a negative right, you also are essentially contributing it to the public domain, where you don't have a right of infringement anymore. And I think in the authorship and protectability context, a lot of times that is lost, and that's going to start becoming more and more relevant, particularly when people are developing software at young companies and trying to hold that as their core IP. But if it's going to be developed entirely by AI, that's going to raise the question. The gray area is exactly as Aamod mentioned, is the human intervention. Where we don't have guidance in the US is what do you mean by human contribution and substantial human contribution? Does it mean that the prompt is detailed enough, or does it mean that you are generating something from an AI tool and then you are further modifying it and adapting it? So we don't have a standard for that. We're probably going to see a standard come up through litigation on that, unless the Copyright Office passes some additional guidance on that point.
Thanks. Tarun, I want to talk to you particularly about the Raghav case that happened, where the Copyright Office initially gave copyright registration to an AI-generated painting and then withdrew that registration but granted it again after the coder who coded the AI applied for it as a co-creator. What are the trends that you're seeing at the court level? What is the court's viewpoint on these points?
So thanks, Nayantara. I think from a pure inventorship perspective, if I limit the scope of my answer in this iteration only to inventorship, most of the jurisprudence that we have does talk about two things. One, from a perspective of the Gen AI platform, most of these platforms will have either a terms or a condition and or a EULA, which will disclaim any ownership as far as authorship is concerned. So they very clearly at least say that we are not the authors for whatever we are being used for. So it is either the user who's interfacing with the platform, who may be an author, or it could be none, for that matter, depending on what kind of data is being generated, which will have various parameters that will have to be looked into. One is the level of contribution that the user has done. So if he's giving very specific directions to the platform to say, I need a character from an animation perspective, which should look like this, the head should look like this, the toe should look like this, and this should be the color, and there is creativity in that input itself, then the fact that the output is coming out of that input, which is creative, will be construed to be, from an ownership perspective, the authorship of that particular author. However, if he's saying, can you summarize this article coming in from NDTV and ABP News or any other, and can you put that across in a summarized fashion for me, and that is what his level of input was, the output that comes out of it is basically an aggregation of different media channels that reported the same news in a certain way. And you've perhaps generated a summarized version of it, but the input was not creative at all because it was asking very specifically for summarization and aggregation of that content. So I think it will eventually, one thing is clear, the AI platform will disclaim. And that's a trend that we see in the EULAs. I am not the author at all because they don't want to be tomorrow sued for copyright infringement from an authorship perspective. So they're not the ones, whether the user or not will be a case-to-case activity depending on what kind of inputs, what kind of output, and whether he has actually further transformed it after the output that has come from the platform.
So you're saying they're moving away from the sweat of the brow test?
That is correct.
Right.
Yeah.
Badri, I would like to move away slightly with you from the authorship space, but ask you, what is the current state of generative AI technologies in general?
So I think very interesting what we've been hearing. I think in the morning sessions also, we had some interesting discussions on inventorship and our own and what it means. And I think that's an issue for all of us. But I think just one of the reasons why I thought I would kind of talk a little bit about the state of the AI so that we understand what is it that we are really talking about. Okay, and we are in the nascent stages of AI, though AI has been around for some time. What's the ultimate goal of AI is what we call as artificial general intelligence. So AGI is what we are trying to do, where without any prompts, the system is able to take up tasks and be able to undertake activities and be able to do that. We're probably far away from AGI. But the ultimate goal of many of the organizations which are developing AI is to get to a place where we are at AGI. Okay? And AGI poses a huge amount of problems with respect to issues. Because the kind of intervention that is required for an AGI system to be able to generate an output is minimal, and therefore it will be difficult to attribute any kind of input or creativity or inventorship for a person who's merely performing or interacting with that. And at the same time, because the distance between the person giving the input and the actual output, which is far away, is so far away that it's not likely to fulfill the test of creativity, originality, and so on and so forth, for it to be given as a protection in that level. So as we go closer and closer to AGI, we're probably going to have more and more problems with respect to how we are going to deal with some of these problems. The second issue is that I think there needs to be a clarity with respect to how AI and who's actually generating output out of an AI. So today, for example, the large language models, the way they're set up and the way they are developing, there are two sets of people who are working on it. One set of people who are actually developing the AI platform, and one set of people who are interacting to generate output out of the platform. On the patent side, there are very interesting things which are happening with respect to how to develop a platform, and is it patentable and merely an algorithm, and how it is to be done. But I'm not going to touch upon that right now. The more interesting things are with respect to how, for example, the person who's ultimately generated something out of the system, whether there needs to be inventorship attribution to the person who originally created the AI or one who really interacted, or both. I think that's one area where there's going to be a lot of issues with respect to inventorship and how it is. But the general thought process is that, I don't know if many of you are following what NVIDIA and others are doing right now. They're trying to bring very powerful chips and computer systems right to the desktop of people. So people like us could effectively have a computer and an AI chip working side by side and be able to generate some of these things. And also the power is so much that we are now having systems which are able to work off 405 billion parameter large language models. So that's really going to have an impact on how some of these things are going to play out. So my general sense is that as the ecosystem of AI gets faster and more developed, we are probably going to have some very interesting problems coming out of it. And I think the real problem is going to be as we get closer and closer to something like an AGI, where we are probably going to see very heightened sense of issues both from copyright and patents in this area.
Wow, okay, that was really interesting. So one of the common problems we face is the lacuna in the regulatory system. Law takes time to catch up to technology, and technology is changing every day. So, Mr. Aamod, I'd like to put the question to you. If you could give us like a brief overview on the regulatory landscape, of course touching upon US and EU, but particularly in the Indian perspective, given the recent regulatory notifications that have come out.
Thank you, sure. So the EU was one of the first, to come up with a regulation, the AI regulation, the AI Act, which, very detailed, the entire process and what are the safeguards. So there's a harms-based approach where, you need to look at what is the harm which comes out of this and how do you protect it. There is also a lot of, deep dive they've done as to the protections which need to be built in. Now, very interestingly, they've also come up with, so this is a risk-based approach, and similar to the GDPR, for non-compliance, Section 99 or Article 99 comes up with the penalties. And the penalties can go as high as 7% of the global turnover. So these are, stringent measures they've taken. Some of the other countries which are still developing have taken a slightly more open view of this, and they're still coming up with what kind of structures to come up with, while EU has been more regulated. US, for example, has many states, and we will hear Shruti talking about it later, but many states have actually got up and proposed bills. There are some directives, but the thing I would like to talk about is the No Fakes Act. The No Fakes Act in 2024 was introduced to protect the deep fakes, which are a malaise to society. So deep fakes, which are typically the protection of the voice and the likeness, okay, image likeness. And this act, in fact, gives the right to continue post the lifetime of the individual, okay, because that's where the misuse is most likely. Imagine a dead person who's been recreated through AI and made to speak lines which he never intended to speak. And that's how you protect personality. So that is where it is. The UK has a slightly different view. They've still not come up with a structure, but they are coming up with a plan. There is a proposed regulator that they are talking about. So let's see how that develops. But coming to India, okay, so India has been at the forefront in a lot of sense. The Niti Aayog has a policy, the AI policy, which has been up there. But as of yesterday, the government has announced a special AI focus that they have come up with. So they have come up with something called the AI mission, okay, the India AI mission. Now this India AI mission has been under the aegis of the METI, the Ministry of Information Technology, and they will be coming up with a lot of these discussions, which is now open for public consultations. So the stakeholders have been asked to come in. So they are looking at what are the ethical ways of handling AI, what are the kind of systems, the risks that are to be built in, and the what is called deepfake detection tools. So they're coming up with a lot of that currently. There is also something that they have proposed in terms of the GSC, which is the Grievance Appellate Committee, which will look at any grievances which may be raised. So these are the kind of redressal mechanisms which have been proposed. And let's see how that comes up with, because that is something which the government is really focusing on. At the same time, interestingly, last year, MeitY came up with a directive, which was to identify AI-generated content through labeling. So like we have influencers who have to label themselves as paid influencers or paid content, they have to now label. So if you've used the Meta AI model recently, it generates an AI image, but it also tells you this is reimagined by AI. So they started labeling it. So you can now, they want the audience and the viewers to distinguish between what is the real and what is AI generated, because that's not, so that's the movement.
So I just wanted to add more from a legal perspective as to what's going on with the ANI case that most of us have probably heard about, just not because it's at a very early stage. So taking cues from what happened there, what are the key issues, plus what happened in the New York Times case, and what happened in a couple of other cases in Europe, I just thought I'll probably flush across certain aspects that the stakeholders in this whole ecosystem have to perhaps cater to and look into. And these are purely practical steps that entities, depending on what side of the stakeholding are they on, they'll have to look into. One is the copyright owner or the protected work owner. That is the first stakeholder in the system. The second is the AI platform, the Gen AI platform on which the interaction is being done. And the third stakeholder in the system is the user who's actually interacting with him. Now, certain points that will have to be borne in mind from whatever we have seen in the cases where liability may fall in, where infringement may get decided, or whether the platform is infringing or not, will depend on several of these following parameters. One is an aspect which is called as block listing, which is where the copyrighted owner or the work, I would say protected work owner, can actually blocklist through a file called as robots.txt, for instance, where on its website or on its web development, it can put in an entry in the robots.txt or some other file that could potentially be utilized during the implementation of the website, which says that no crawlers should come into my website and use the protected work or protected content to train the respective LLMs. So honoring of that blacklisting by the Gen AI platform is the first very important thing, that once you know that a certain entity or a media house is blacklisted, make sure that the crawlers don't find a way to bypass the paywalls, as they call it, or bypass content which may be behind a certain firewall, or paywall is what they call it from a technical perspective. Second is make sure that the terms and conditions in the EULA is very clearly indicative that there's no commercial benefit or commercial incentive or objective that we are trying to achieve out of this exercise. Because that will allow you to play and argue for section 52(1)(a), which is for fair use of the work for that matter. So the EULA or the term should be very clear. We are only transforming the work. We are only training our models. That model training may use certain content which is protected, but whatever is generated is not a literal copy paste, but a transformative work. And we are not, for that matter, in any manner whatsoever, claiming or commercially exploiting that in any context. So it is clearly should become a fair use basis argument. We should also put in a condition for the users that the content generated by the platform should be used only for certain actions which do not constitute activities were outside the domain of 52(1)(a), for instance. So they should not use it for commercial. So they should not basically ask the Gen AI platform to generate certain data and then sell it. Because sooner they sell it, then they become the first defendant in the matter. And if that generated content includes the protected work, and the owner of the protected work, which is the first stakeholder, can prove that whatever was generated was a clear inspiration from the first part, from the second party, therefore will result into infringement. So the third party, which is the user, should make sure that they're not using it for principles which are outside 52(1)(a). Also very important to put in a condition that any commercial use of the platform will or may constitute copyright infringement. The tool should also, which is the second stakeholder, the Gen AI tool, should also give prompts that do not ask that. In fact, GPT also has a condition which says, I am not liable in case you ask me reproduction of what a certain media house is reproduction. So you can ask me for a summary or you can ask me for an analysis, but if you ask me reproduce that content, then I am not liable. So that's a disclaimer, and these are all points from the perspective of the platform, Gen AI platform. Now, there is also very important because in most of these cases, the New York Times case also, there's an allegation that there is misrepresentation of data. Now, that is a very critical element because then you can't evade liability. So the platforms have to ensure that whatever transformation that they do of the content does not constitute a false or a misleading statement being made, because then it will be difficult from a summarization or from a transformation perspective. And also, very important that we claim that we are only aggregating data in case you are asked that what is the position of the Russia war from India perspective as of today, then the platform should be very clear saying that we are only aggregating data from what is publicly available and sharing it across without any commercial incentive as far as we are concerned, and what the users do out of it is neither our ownership and nor within the control or gamut within the platform. So these are 4 or 5 points purely from a platform perspective. If I may just take one more minute, and 3 or 4 points from a first stakeholder perspective. What should be certain things that the protected work owner should look into context, which is a media house, for instance. Now they, as I said, should talk about they should use the robots.txt file to make sure that everything that they don't want to be accessed should be, one, behind the paywalls, should be blocklisted. So they should say GPT blocklisted, Gen AI tool 1 blocklisted, Gen AI tool and it's not like there are thousands of such tools which are prominent. So whichever tools that you get to know of over a period of time, you should make sure that you blocklist them and they don't access anything beyond the walls. Second also is these content which is generated by the media houses is not just accessible on their website. It is also accessible on several third-party websites. So they should also make sure that they control what is going to the third party versus what is staying behind the system as far as the first party is concerned. If they don't want crawling to happen from third-party websites and protected work being copied from there, they've got to ensure that they have practices to keep everything behind a sign-up or a subscription or a paywall for that matter. And in case of any infringement, we have to reach out, I think which was done in the certain cases as well. They have to reach out to the Gen AI platform and tell them you are an intermediary, but using your platform, our protected work is being used to train. Please halt that process, which is what happens in e-commerce models at any point in time. So we have to treat them like an e-commerce entity as an intermediary and intimate them and treat them as a partner so that whenever we do see infringement instances or user protected work, we intimate and make sure that it is sort of halted in that context. That's it.
Then I have a little bit of a perspective to show here. See, we're talking about AI platforms, etc., as if they are some kind of a separate entity. You know, you have to be a little real about this. The reality of life today is that, for example, AI is part and parcel of each and every software that you get. That's a real thing, and that's what is going to happen in the future. Your Manupatra is going to become AI assisted. Your SEC online is going to be more and more AI assisted. So you're going to have it. I'll give you an example. Like you have like photographers. You take photos. Like take a photo of this room. I don't like this yellow light. I want it to be a little bluish. So there's AI. It's integrated and part and parcel of the software. The work that comes out of it. Today, the photographers here have taken so many photos. They can just go to that software and then just say, okay, we want a little greenish tinge in this or a little bluish tinge in this, and then you will have it. And maybe you can change some of the audience also. I don't like this part of the people. I don't like those people. I'll have some of them replaced. Yes, AI will do it. And it will give you. So that work which you are now getting is by me. Me, I am the photographer. I am the person who has taken it out. If you're not talking about patent applications, they are a bit AI assisted. Basic draft is made by some AI kind of a platform. And then I am improving on it. So we have to think in the future in that way, rather than sort of thinking that, no, we will shun them, we will not have them here, and we will not have them there. You will have to integrate it. So you will have to have legal systems, or we'll have to have laws whereby you say, all right, if it is part and parcel of the software that has done it, and if you, as long as you claim ownership over that work, You should be the author. AI is never coming to you and say, make me author, make me author. He never says so. He's only assisting you in that work. So you have to take responsibility for that work. If you've taken responsibility for that work, there ends the matter.
Right. Just to take it a little further from there, Shruti, I want to place the concerns of infringement and how the US handles concerns with infringement when it comes to training data sets.
Sure.
So if you could shine a little bit of a light on that.
Of course. So the two biggest areas of litigation in the US when we talk about generative AI is one on the training data sets that the LLM models are being trained on. And there you have companies like New York Times, you have authors like Sarah Silverman that have filed a lot of cases in various US courts alleging that the materials that OpenAI, for example, is being trained on is copyright protected and therefore constitutes infringement of their work, particularly considering that OpenAI and the like are quote unquote using it for commercial purposes. This is an interesting position to be in because the US does not have a data mining exception for anything the way the UK and EU have for various reasons. The courts have not opined on this yet, and therefore it begs the question is, are players like OpenAI, Google, Microsoft going to be liable to all of these authors? Where that's headed is two places. One is the use of the fair use defense. What the LLM companies essentially say is that, sorry, we're not infringing anything because whatever we're doing is resulting in a transformative work, and the data that we're using at the end of it is resulting in a transformative work, and that's allowed under the US fair use defense. The fair use defense is a very well-established 4-part test in the US. One, it talks about, are you changing the purpose of the original work? Are you changing the form of the original work? Are you in any way taking away from the market of the original work? And are you using an exponentially high amount of copyrighted work that was not required to create this transformative work? And where the LLMs have come out is basically saying, look, we're only taking the training data to form various structures and various ideas about how all of the questions that are given to us should be taken and build out the parameters based on which we're giving the output. And the output is not a copy of your original work in any event, and therefore this cannot be copyright infringement. That's still an open question, and that's going to dictate a lot of the future of generative AI and copyright law in the US. The two things that are happening to counteract that is a lot of companies are actually entering into settlement agreements already because they can see that their output is similar enough to the original training data where the fair use defense might not hold. In those instances, we're starting to see settlements happen. The second place that we're seeing a lot of movement in the US is licensing. Where that's happening is when you have a lot of these media and publishing companies, they don't want to now be on the other end of it and take the risk that, well, what happens if the court actually says it's fair use and now we've not been able to monetize it because this was completely allowed, it's not infringement. So they're hedging their bets and they're going to OpenAI and saying, look, we'll give you a license for all of our data and you pay us X amount of money, you pay us X amount of royalty, you give us an attribution and we are going to let you use it both for training data and even in the output that you're bringing about. And that works out really well for the data owner because that gives them attribution that opens up a new market and opens up a new monetization channel. And it works really well for the LLM because they don't have a copyright infringement risk that they need to defend against. And so it's going to be interesting to see how this plays out. If I had to, hedge bets anywhere, I'll say we might end up in a compulsory licensing model eventually with respect to training data particularly, but time will tell.
Thanks, Shruti. I think one of the other things that a lot of companies are developing now is something called data poisoning tools, where they actively prevent the data being used for training models, and in case they are taken in despite your paywalls, etc., is where they give you skewered results, so the credibility of the generative AI is then affected. But from your licensing point, if I can take it forward.
Sure.
Badri, I'd like to ask you, what are some of the licensing and data issues that generative AI applications pose?
Thanks. I think just carrying on from Shruti, I think some very interesting things. So what are we really seeing? I think one is, of course, the algorithm and the actual regression models and other models being put in place for the purpose of developing LLMs. But that's only going to give you the framework. You still need to feed it with the data. And it's not, and feeding data into a LLM model is a very interesting thing, because LLM model got multiple layers. When you feed the data closer to the output layer, it gives you very mild AI. If you feed it further down the list, it gives you. So the way the data is taken and put into the system is very interesting. So what are we seeing right now? So we're seeing a lot of companies, recently at least, which are being invested only to collect data. So we had in the Anand session a whole point about piracy. Okay, and so we had this whole issue about how the media companies and others have faced piracy or this thing. Data is going to be new piracy. So there are two aspects to it. One is being able to protect data poisoning softwares and systems and so on and so forth. But the bigger thing is that today there are companies being set up only for the purpose of being able to collect data, where their primary monetization is data selling rather than being able to do that. The second thing is, whenever you negotiate a data agreement or a licensing agreement, you just don't negotiate what is it that you're giving, but also level and extent to which it is going to be used. And at what layers we are going to be using these data. So data licensing itself is fairly complex system. So we are seeing both from the transactional perspective as also from a licensing perspective, new standards being put up for the purpose of being able to, one, collect data, being able to sort the data, license the data, and then to be able to monitor how this data is being used in the AI. And finally, how is it being given as an output when the various tools are being used for that. So that's very, very interesting. I think data licensing and licensing in general is going to become very interesting in the future as we go through this transformation.
So licensing is the key to the game, is what you're saying. Taking it from there, Aamod, I'd like to put to you, what are the general licensing structures that you are seeing that is coming into play in the generative AI content space?
So what's happening is, because AI is essentially deemed to be public domain, you can use it really for training, research and development, for creating what are called generic information. But when it comes to commercial use of it, it really depends upon whether it was originally, how much of human intervention can you really put to that. Else you'll always be ending up with a lawsuit, because you will not have the ability to prove ownership and you will not be able to sustain it. On another point, I just wanted to add to what the panel was saying. The AI policy, which has now been announced by the government yesterday, has a very interesting point. They say Section 79, which is the safe harbor, does not get attracted for AI, because AI, according to them, fails on the point of not create, intervening. They intervene, they create new things. So it will not be able to get a Section 79 protection. So it's an interesting way to look at it.
So coming from what Aamod just said, I think it's also interesting to see how different countries are looking at legislation very differently and how they're looking at AI very differently. In the US, you basically have law being made in 4 different ways. One is the executive order, which has really been the marquee way of AI policy in the US, which Joe Biden passed in 2023. And the executive order essentially was from a lens of promoting innovation, but also protecting national security. And it really empowered all of the agencies like the USPTO, FTC, FDA to come out with their own regulation and guidance on how you're dealing with this. And then you have, the federal legislation, which Aamod mentioned when you're talking about the No Fakes Act, but really going on to the copyright piece that we've been talking about, both in terms of training data and output. One of the bills that's really gaining steam is this bill that would require every LLM to disclose to the Registrar of Copyrights prior to release on what training data was used. And the idea behind this is to increase transparency, but also allow for attribution. And so that kind of is going to be an interesting one. If that passes, where does that leave you with licensing? That's right. And so that's an interesting one to think about is the law finally going to catch up in a way that the industry is going to have to change the safeguards it's finally brought onto itself. And the US has an interesting third aspect to it, which most jurisdictions don't, is state law regulation and laws. And that's been really active in the US with states like Tennessee, Chicago, Utah, really coming up with their own laws and own baseline about how they treat AI. And you mentioned this, when you were talking about things like Adobe with inbuilt AI, how each state is coming out with its own interpretation about what an AI tool is and what an AI-generated work is, and whether it has to be a standalone tool or whether any AI-assisted technology in an existing tool would match that as well. And just kind of want to leave everyone, as we're talking about this, with a few thoughts, right? It's not going to be one standard globally that's going to apply. And so just kind of circling back to the licensing conversation, you're going to have to take care when you're doing a data or an AI-related licensing to take care of three very important things. One, you're going to have to take care of how the laws change in the jurisdiction you're working in, because that's going to dictate whether what you've licensed is actually tenable or not. The second is, for what purpose have you licensed it? Because AI technology is moving at very, very fast pace. So you might not fully understand how your data can be used in the future, so having guardrails around it. And third, even though you might end up deciding to do an AI license in India with the governing law of New Delhi, that same AI model might now be used in the US, which is going to have different laws. And so it's kind of going to be interesting about how companies also manage all of these jurisdictional discrepancies. Because even when we're seeing a same standard of authorship or inventorship, we are seeing different jurisdictions take a very different stance on what's permissible within them.
Thanks, Shruti. Before we close the session, because I'm being told we are time bound here, I just want to ask Rajeshwari. Rajeshwari, you have come in from a very patent perspective. So could you give us an idea of what the impact of AI is on patent prosecution, particularly patent examinations?
So very interestingly, our patent office is now trying to use tools for searching. So that's a very big leap. So they are trying to integrate AI into patent searching. So that's going to make patent searching very interesting. But then it will raise different kinds of questions. And now, of course, there are lots of people who are using AI-based tools for drafting. There are already some people who are here. Currently, people are using AI for drafting, and they are using it for searching as well. So now, if you are going to use AI for drafting, who takes care of the errors in that? Who takes care of the ownership of that kind of a draft? Then, if the invention by itself is AI assisted, then how much is your inventorship? What is your role and what's your level of contribution? Number one. Second, what should be the level of the person skilled in the art? Should it be just an ordinary person skilled in the art, or should it be a little bit higher because now you've got the assistance of someone who knows everything? Already you've got that kind of a person's assistance. So should it be higher? So as I was saying that, these are things that will have to evolve on a case-to-case basis. In some cases, if you're just using a tool, for example, to develop a molecule, you already have some molecules which are known, and AI is helping you to develop a new molecule, a new group to be added into that. And it's also doing some kind of nearly human kind of, not human, but near wet lab kind of tests and telling you, yeah, this is a group which will absolutely work. So then when someone is trying to invalidate that kind of a patent, then what should the person look for as prior art, and what should the patent office look for as prior art? So when the patent office is using tools, then they should also be much aware of this and then look at it in a more, higher perspective. So that's the kind of perspective that I thought of that we should have.
I think, Rajeshwari, these are all complicated questions. And
Very complicated issues.
Very
That's why I
complicated.
said it has to be resolved on a case-to-case basis.
Yeah. The only thing I keep saying is that if I buy a lathe machine and I cut my finger off, can't have the person who has invented the lathe machine to be the person who's caused this liability to me. So
Which
if I
is
use a
a very-
tool for drafting and there's an error, I think really the responsibility is on the patent attorney,
Agent.
not on the person who has made the tool. At least not
No,
yet.
obviously the agent has to take the ownership, but then again he cannot come back and say, no, it was AI assisted, AI gave me this draft, I don't know how this error came about.
This kind of complicates when you look at a self-driving car, for example.
Correct.
Which is purely AI assisted. You don't control that. Let's say there was an accident, then is it the AI, is it the manufacturer, or is it the person, so those are the kind of questions which come up from that perspective. It also adds up to what is called the EU has this product liability perspective. So, a lot of that is evolving, but essentially it's the AI which, is driving that incident.
The only thing I'll add to that is just make sure your indemnity and liability sections are really well considered, whether you're an LLM model provider, whether you're a licensor, whether you're a service provider. Because that's really what's going to cover you in all of these situations.
So is there something you'd like? Okay, so I think we're out of time. Yeah, all right. So this was a really interesting session. I think one of the key points that came out is that while AI is helping us create, it is still assisting human creativity, and the buck stops with the humans. So supervisory overview of AI is, I think, the primary key that has come out from all of this, be it transactional, be it patent, be it copyright. We're still pretty much important, not yet replaced by transformers. So with that, I'd like to close the panel. Thank you very much to my esteemed guests. Before I close out, I just want to know if anyone has any questions that the panel can answer.
For prior art, if you are using the AI tools, then that itself becomes disclosure to the public.
Sir, it is not like that. The way the prior art tools operate, at least as I understand, not just in prior art, other places also it operates, is that there is a data which is universally used for training and keeping the prior art. But when you do the search, it is not forming part of the training or the data of the prior art tool itself. So it temporarily creates an output for you, and once the output is done, it gets deleted and doesn't form part of the rest of the art, and therefore a prior art search will not
But in
result
AI
in this
tool,
thing.
how do you know where the data goes?
That though you have to rely on
that's
God's
the-
Almighty.
that's the
but
complication.
but the way at least whatever I've seen from the AI tools which are currently being used, there is a tool that has been trained. The training happens so that you're able to do a prompt. The prompt generates the data. Then the data can either go back to the universal set of the AI itself, or it gets deleted. So for example, many of the tools like LexisNexis and others and all who are developing, they generate the output, but the output doesn't form part of the data itself. So it does not form part of the prior art itself.
Just one comment also. You can also configure your the prior art search tool with the vendor in a manner so that those instances that Badri is talking about are locally created. They are never sent to the server at the backend at all. So there is a setup that you do where the tool is installed. The results are procured from the backend, but the instance of that particular search, the string that you add, and the instance that is created, data being fetched from the backend, is all created and destroyed within that particular completion of that string itself. So the data never goes at the backend for retraining purposes of the LLMs at all. So and that's an undertaking or a liability that the tool providers also sort of give in totality.
Thank you. Any other questions? Sure.
I think based on all these discussions, especially in the area of patents, the whole question, I think that we need to sort of ask again, is to who is a person skilled in the art? The whole definition of person skilled in the art should be changing. Because it's no more, as you go in the definition of that fictitious person skilled in the art, that fictitious person is becoming more fictitious. So you need to really relook at and revisit the whole concept of person skilled in the art. And the moment you do that, the whole question of inventive step changes. So the entire perspective of patent law changes. I think we need to rethink some of these parts. Thank you.
Very interesting point, sir. Thank you. Are there any other questions? Wow. All right. Thanks, everyone. Thank you, everyone. Thank you to my esteemed panel. And I hope you guys had a good session.
Thank you very much for that wonderful session. Now I'd like to request Ms. Nayantara Sanyal to felicitate our panel members. First up, we have Mr. Aamod Gupte, Group General Counsel at Balaji Telefilms Limited. Next, Ms. Rajeshwari Hariharan, founder of Rajeshwari and Associates. Next, Ms. Shruti Chopra, Counsel Intellectual Property at Linklaters. Mr. Badri Narayan, Executive Partner at Lakshmikumaran Sridharan Attorneys. And Mr. Tarun Khurana from Khurana and Khurana. Now I'd like to call upon Dr. Agarwal, Honorable Founder of GIPC, to felicitate Ms. Nayantara Sanyal, Partner at ALMT Legal.